First, the introduction. It's three. Friends, we are going to start now. Today is the 218th Friday group meeting. The topic is Islamic law, its intricacies. The speaker is our beloved senior advocate, Mr. A. Sirajuddeen ji, topmost senior advocate in this country and particularly criminal law. Actually, last minute efforts, so I requested immediately accepted. Till date, we have not discussed any on Islamic law. That is also another. Sir, you addressed our Friday group on 16th March 2018. That is 74th Friday group meeting. The topic was criminal liability of public servant for an offences under Section 138 Negotiable Instrument Act. So, thank you very much. I request, our Nasir Bhai will give a small CV. Up.
Good afternoon, everybody, my friends and everyone. Good afternoon, everybody, my friends and everyone. Gradually in the subject of cooperative secretaryship in the 1984 and got first rank in Madras University. He passed the law in second rank in the university. He passed ACS examination the same year, but preferably practicing of law. He has authored 8 law books of different subjects. The right of professional criminal investigation, trial, judgment, statutory, and few among them. He was also the chief consultant editor of Monthly Law Journal also. Currently Indian Judgment, he was the designation as a senior advocate on 31st March 2016 by Madras High Court, and from 2017 September he has been practicing before the Supreme Court. And he is the master of all the subjects including civil, criminal, and corporate. Thank you very much.
Thank you, Nasir Bhai.
Friends, before commencing my lecture, I cannot say that it is a lecture, it may not be a proper term. I should treat and recognize the efforts of the organizer of this function, Mr. G.Seshagiri, because organizing 2 centuries of lectures, and it has crossed, now it is 218. It is a very stupendous task. Even finding topic for giving lecture, it is a very tough task. So with your permission, I am just...
Sir, can you avoid, sir? I am
because
just, I avoid, sir, generally. Sir.
So,
Thank you
now,
very much, but sir.
Now the topic is on Islamic law. It would go on for a number of days, which was recognized by our organizer, and now today it is only on the preliminary subjects. First of all, before going into the chapter on Islamic law, in Muslims they call God as Allah. So they call us Allah is the only God. Now a person is a Muslim. For him, what is the law applicable? How the law was developed for the Muslims? See, the basic document which granted law for the Muslims are, the first basic document is the Holy Quran. The Quran contains many commandments regarding the human behavior, how the human being should behave on religious aspects, civil aspects, and other things. Many things are there, even criminal law is also there. But so far as our country is concerned, on criminal law, we are having secular law. Even on transfer of properties, we are having secular law, Transfer of Property Act. From the year before the year 1937, except on criminal law, on all other aspects almost, the Islamic law was applicable to all Muslims. But it was only by customary practices and by the charter issued by the British King and Queen. There was no law at all to this aspect to give effect to the customary law which is evolved out of Quran and other things. But in the year 1937, an act was passed by British Parliament. Muslim Personal Law Sharia Application Act 1937. This was the act, just a small act. This act contains one mandatory provision and another section gives an option. The mandatory provision says that except on some aspects, just like adoption, on all other aspects, for a Muslim, the Islamic law is applicable. No option at all. But on the chapters like adoption, the said act specifically says that if there is a custom among the Muslims which is contrary to the Islamic law on any aspect, these aspects, just like adoption, then at the option of the party, the customs can be moved. The Islamic law may not be used. So, but it is only on one or two circumstances, not on all aspects. All other aspects, the Islamic law is compulsorily applicable. Now we would understand how the law was evolved. See, the primary source is the Quran. The Quran contains many commandments regarding the conduct of human being, Muslims. How whether a person has to marry, how the marriage has to be conducted, what are all the conditions for valid marriage, then after marriage, how it should be dissolved, on dissolution or on marriage, what are all the obligations of the person who are married, regarding the right to maintain the wife, right to maintain the children, how the properties can be gifted, how a person can be adopted, like this, almost number of civil subjects. The commandments are there, but they are not exhaustive, just like our constitution. We know constitution is having some fundamental principles, but it is supplemented by the law enacted by the legislatures. Assemblies are there, parliament is there, and sometimes article 161 is also used to issue directions. Beyond that, the judiciary is following the principles of justice, equity and good conscience. It is also there. It is only to supplement this substantive act, like that. So far as Islamic law is concerned, to supplement the directions contained in Quran, the first thing is the commandments of the Prophet. The Prophet, he has given some directions by his own practices. What is the rule? How it should be? Like that, he has given directions. This is called Hadith. A book is there on the subject which is called Hidayah, written by Macmillan. It is an authority on the subject. Then during his lifetime, he gave so many directions. In a particular situation, how a dispute has to be resolved. But after his demise, he was also a human being. After his demise, then suppose if in a given situation, rule is not there, or we are not getting guidance either from Quran or from his own directions hadith, then the thing is, the persons who are following, the religious scholars, the persons who are following him when he was alive, they used to say, see, in a particular situation, the Prophet said something like this. So, this should be the law which he intended. Like that, the intention of Prophet, which was derived from his own conduct. They were observed. Then thereafter, even that one is not available, then justice, equity and good conscience. So these are all the ascendancy or descendancy in which the law has to be applied. Suppose if there is any conflict between the equity and good conscience with the commands in Quran, the Quran prevails. If there is any conflict between what Prophet said and the Quran prevails. Like that, Prophet said justice, equity and good conscience, conflict. Only what the Prophet said, that is the law. So these are all the ascendancy or descendancy in the law applicable for the Muslims. Now, general principle I have told you. We would come to the aspect now. What is the impact of customary law? We know that in our country, apart from the written text of law, there is a customary law. Now law is supreme. Supremacy is only for the Constitution of India. Subject to the Constitution, the law passed by the legislatures. Then subject to these two things, customary law is there. Then justice, equity, good conscience, all these things are here. Just like that, so customary law can be invoked only when there is no law available in the Quran, Hadith and the practices of the Prophet. So it occupies the 4th place or even 5th place. Now we come to the main law. We commence from the marriage. See, so far as marriage is concerned, different religions attaches different concept or reason. So the concept is, it is a sacrosanct. So since it is a sacrosanct, the procedures are getting much importance. Suppose there is no consent between the parties, all the ceremonies are observed, then automatically the marriage is varied so far as Hindus are concerned. And I request you not to mistake me, because subject is only Muslim law. I am touching upon Hindu law also and other laws also, because we would be in a better position to understand comparatively. So far as the Hindu law is concerned, Hindu marriages are concerned, the ceremonies are getting much importance because of this concept of sacrosanctness in this marriage. But so far as the Muslims are concerned, it is only a contract. We know what is contract. Section 2H I studied in 1984, in 81 I studied. It is an agreement enforceable by law. So far as marriage is concerned, it is an agreement between two persons for the purpose of legalizing sexual intercourse and the procreation of child. It blatantly says, just you ignore the religion. A person wants to marry another person. A male wants to marry a female. What is the purpose behind it? See, we forget the religion. The religion, it is a different thing. Our thinking is, we are having some kind of attraction towards the other sex. So we want to live together. The primary purpose is live together. Then consequence would be the child. This is why Islamic law says the marriage is a contract between two persons of opposite sex. This is why the Islam is not recognizing the gay relationship or gay marriages. Islam says it should be between persons of two sex. For the purpose is only twofold: legitimizing the procreation of children and legalizing the marital relationship, the sexual relationship. So it is purely a contractual relationship. That is why when two persons are having an option to unite together for these two purposes, and if they think that they don't want, they can freely break from each other. You see, suppose I am buying this specs, and for the purpose I am going to a shop. They say one amount, I am negotiating, I am agreeing, paying money, they are giving me this specs. Contract is over. After buying these specs, suppose if I feel I don't want it, I am telling the shopkeeper, he agrees, I am returning and getting back the money. Contract is broken. When we are having a free option to enter into contract and break it, in other relationships, in other transactions, similarly in Islamic law also, when two persons of opposite sex, they are having free will to enter into contract of marriage, they are having the very same free will to break at their choice. The only thing is they should exercise their mind freely and they should be having some reasonable ground. So only on this basis the law surrounding the marriage and divorce has been framed and it has been evolved in Islamic law. So far as marriages are concerned, we know that it is only a contract. So far as contract is concerned, we know about free consent and age of consent. It is in Indian Contract Act 1872. What it says, Indian Majority Act says, a person who completed 18 years, he is a major. Before that, he is only a minor. A contract with minor, if it is advantageous to him, he can enforce it. Otherwise, it is void. We know that this is the law. So far as Islamic law is concerned, it says, instead of using the word major or minor, it uses the term age of puberty. See, a person who complete the age of 15 years, they are taken as a person who attained age of puberty, male or female, there is no difference. So a marriage can be performed freely between two persons if they are of age of puberty. So the marriageable age is age of puberty. It is only 15 years. Suppose if they are of lesser age, they can also perform the marriage. If the marriage is between two persons of age of puberty, the consent of the parents or their guardian is not at all necessary. The only requirement is this offer and acceptance. It is a case of offer and acceptance. Either the male or female should offer, I like to marry you, whether you are giving your consent. The other person should accept it. On its acceptance, and this offer and acceptance should take place in the presence of two persons. So when offer to marry and acceptance of the offer takes place in the presence of two witnesses, then the marriage is over. No religious ceremony, nothing. But in practically in all Muslim marriages, the Imam comes. Even next week, in another 4 days, my son's marriage comes. Naturally, Imam comes because people follow it. We are also just like hers. We are following it. It is the procedure is very simple. Even assemblage of persons, this is also not necessary. The couple who are intending to get married, they should express their willingness freely. There should be a free consent. And this free consent, offer and acceptance should take place in the presence of two witnesses. On completion, the marriage is over. Suppose the person, one person or two persons, they are not of marriageable age. Can they do it? Yes, they can do it. This can be done through their guardian. So on their behalf, the guardian can exercise this right. So even in this case, two witnesses, offer and acceptance. On completion, the marriage is over. Immediately, the relationship of spouse is created, husband and wife. Suppose the persons are of not marriageable age, that is lesser than the age of puberty, and they are getting married. Now, one concept is there in Islamic law, the option of puberty. On completion of, on attaining the age of puberty, so I am talking about only about law. On completion of age of puberty, or on attaining the age of puberty, the person who was not of pubertable age at the time of marriage can rescind it by exercising his right. He need not go to the court. See, courts are of recent inventions only. Evolved by only maybe in another some 100 or 2 or 3 centuries. Before that, there was no court at all. So, on attaining the age of puberty, the person who was contracted into the marital relationship before the attaining the age can revoke it, but this can be revoked in the next 3 years, that is before completing 18 years. This is called the option of puberty. Now, how many marriages we can have? See, so far as Islamic law is concerned, some legal provisions were evolved to meet the situation that was prevailing at that point of time. But it is being continuously followed even now. One is the bigamous marriage. You see, at that point of time, some 1400 years before, see, the entire community, not only in Arabia, everywhere, we know that. Even when we are reading the fight between England and France, there are many write-ups. Everywhere in all countries, all continents, there were fights in which only the male member would go with arms. There would be many killings. So necessarily what happened was, in those communities, the number of male people were lesser. And at that point of time, in Saudi Arabia, that continent, Arabian continent, the number of male members were predominantly less, but females were more. So in order to address that situation, what happened was the likeness or willingness to get married. You know what is the purpose of marriage? It is a civil contract for two purposes. The first purpose is predominant at the initial stage. Just like male, female, they are also having the same likeness. To address this situation, at that point of time, the Prophet said, you can have 4 wives at a time, simultaneously. So the concept of bigamous relationship was recognized for male to address that situation. But even now it is being continued, and some people claim that it is our right. We need not address whether it is correct or not, because it is not the place here. But so far as the females are concerned, only monogamous relationship is permitted in all laws. Hindus, Muslims, Christians, all laws. And there is one more type of marriage, which is called muta marriage. See, so far as Muslims are concerned, there are divisions, there are no caste. In Hindu communities, we know that there are caste system. It is a basic thing. A person is born into the caste, he cannot change it. But so far as Muslims are concerned, there is no caste, but there are divisions. The basic division is Shia and Sunni. See, on the demise of Prophet, who has to succeed the kingdom? Prophet, when he passed away, he was a king. Who has to succeed? There was a Khilafat, the Islamic kingdom. Who has to succeed? There was a dispute between his own relatives. Some people said it has to go by succession only. We know that the first eldest son, he would become a king. In our country, everywhere it is there. This concept was liked by one group. Another group said, no, we have to select a better person. This was by another group. This dispute could not be resolved at that point of time. The persons who supported the principle of succession, they were called Shias. The people who said that we have to select a person, a better person, they were called Sunnis. And this division has become permanent now. So, but so far as India is concerned, the presumption is almost 95% of our people are only Sunnis, our Muslims are only Sunnis. So when we are invoking the Islamic law to any situation, we have to follow only the law which are applicable to the Sunnis, not the Shia. Because the presumption is that unless otherwise proved, the people, Muslims in India are Sunnis. But is there any remarkable difference between the two laws? No, there is no remarkable difference. There are something procedurally. In small aspects, there are some differences. One such a thing is muta marriage. You know that among the Shias, this muta marriage is recognized, but Sunni law is not at all recognizing this muta marriage. Everyone knows that the people, they are migrating to a number of places and settle there, and their family is somewhere. Even I am here. My family is in Tamil Nadu. Not only this is going on. So in those days, what happened? There was no transport at all. They used to go only by camels in Arab countries. Here also horses. It is going on in every places. So when a person moves in a camel to hundreds of kilometers or thousands of kilometers for trade or for any other purpose, even in war, king goes from one place to another place. He is residing there for years together, individually. Islam bans prostitution. Islam bans the relationship outside the religion, outside the marriage. It is a greatest sin. So, when a Muslim settles in one place temporarily for a longer period and prostitution is banned, extramarital relationship is banned, what is the recourse for him? So, to address that purpose, Shia law says you can have a temporary marriage, that is muta marriage. You can enter into a marital relationship with another woman. That is not a permanent relationship. That is for a period specified at the time of entering into a marriage. Suppose you want to live with that particular woman for 3 months. Yes, enter into a relationship. Say that it is for 3 months. What is the consideration? You should fix the consideration. As long as I am living with you, I am paying you this, I am taking care of the family. After the end of this period, I will pay you this lump sum. Like that, it is also a contract. On completion of that term, automatically the marriage gets dissolved. Suppose child bonds in that relationship, that child is a legitimate child. You know that in Hindu law, so far as the property rights of legitimate and illegitimate son are a little bit different. In case of self-acquired properties, whether it is legitimate or illegitimate, the children are having right. In self-acquired properties. But co-possessory property succeeds only to the legitimate children. Difference is that. But so far as Muslims are concerned, Islamic law is concerned, there is no concept of co-possessory property. All properties, suppose I get property belonging to my grandfather or great grandfather, whatever may be the thing, all the properties are my own properties if I get it. My grandson cannot, no, it is my grandfather property, he cannot claim anything like that. Islamic law is not at all recognizing such things, so we would discuss this aspect when that chapter comes. So, Islamic law is not at all recognizing extramarital relationship. Islamic law says only when a child is a legitimate person, he gets right to succeed to the property, and illegitimate child is not at all having right to succeed to the property, whether it is a mother or father, whatever may be the thing. Only because of that, the law specifically says, in case of muta marriage, a child born or conceived during the existence of that muta marriage is a legitimate child, because the concept of legitimacy is having importance in other aspects also. I will explain later. And there is one more incident, one more aspect in Islamic marriages. See, in marriages, normally in our communities, in our country, what happens? Family fixes the marriage, or the couples, they fixes. Some ceremony is done, marriage is over. Dowry system is there. The bride's family, they pay something, they give something, it is there. It is there, the marriage expense, all these things are there. But the law is not saying anything about the granting of any amount or any property by the boy side to the girl side. Maybe they may voluntarily follow it. In Hindu law, there is no such a concept of granting or demanding a money from the boy to the girl at the time of marriage as of right. But so far as Islamic law is concerned, this obligation is there. This is called mahar. This mahar is an Arabic term, and in English it has been translated as dower. At the time of negotiation of marriage, the girl should, as of right, it is an obligation of the boy. As of right, the girl should demand, how much you are paying me. It is a reverse of dowry system. The girl should demand, how much you are paying me. The boy should pay. You know that in Arab countries, number of boys, poor family, they are unable to get married because they are not having money to pay this dower. And the government, the Saudi government is extending money to enable these boys, poor boys, to get married, to pay this dower. It is there. So, this fixation of dower amount, this mahar amount, it is compulsory. What is the quantum? This quantum depends upon the status of the girl. See, this is how the mahar is fixed, because it depends upon the status of the girl with whom the marriage is being performed. Poor families, 50,000, 1 lakh, 2 lakhs, like that. But it need not be paid immediately. This payment also depends upon the agreement. I may pay it. I may means the boy. It is a personal obligation of the boy, not of the family. The boy who is going to get married, he may pay it immediately. This is called prompt dower. Suppose he is not having the money, he may agree to pay it at future point of time. This is called deferred dower. Suppose if it is prompt dower, it is being paid immediately at the time of marriage itself. If it is deferred dower, if it is not paid, in between the boy passes away, what would happen? Say at the time of division of the properties left by the boy, the property can be subdivided only after adjusting this dower amount. So the widow is having the first right over the properties to take her mahar, then only the balance should be apportioned as the property left by the boy. So this is the concept regarding dower. Suppose in case of divorce, what would happen? In case of divorce, and till divorce the money is not paid, the woman is having the right to demand that amount. This dower, for that purpose, previously, before this Shabana case, previously the law recognized, but the person, in order to claim the money, he has to go only to the civil court. Suppose 10 lakhs amount is fixed, he has to pay court fee and file the civil suit, prove this amount. Then it will take some time to enforce it. After Shabana case, Muslim Women Protection of Rights and Divorce Act was passed in 1986. In that, the right to recover this dower amount through the magistrate court was recognized. So under this act, a petition can be filed before the court of magistrate by paying a small court fee. Court fee differs from state to state. In some states there is no court fee at all. And by proving that mahar was not paid and this was the quantum, we can get an order from the magistrate, and if not complied with, the magistrate would use his coercive powers to recover it. So this is a provision regarding recovery of dower. Now we go to the persons between whom this marital relationship can be entered into. See, in all laws, Hindu law, Christian law, but so far as the Muslims are concerned, there is no such exception, but list is there. What it says is, a boy cannot marry his father, a boy cannot marry his mother's mother, like that. He cannot marry his sister, his daughter's daughter, like that. Ascendancy and descendancy. A girl also similarly like that. And the sister of his mother. So far as the girl is concerned, the brother of his father. Like that, this list has been given. This is called a prohibited relationship. So the marriage just like Hindu law. If anyone marries a person who are within the prohibited relationship, that marriage is void, not at all valid. In other laws also the same thing. Now, number of marriages, that is a controversial subject. I told you that so far as male is concerned, Islamic law says you can have 4 wives simultaneously. Even in a single marriage ceremony, you can have 4 wives. This is what being advocated by scholars. But the real thing is, normally a Muslim male can have only 1 wife. This is a normal law. But there could be some circumstances in which he would be compelled to have another wife. Take for example, his wife is so serious, she is unable to take care of it, and his marriage life is almost gone because of the health hazard. What other people has to do? Either divorce, or beyond marriage he should have some kind of other relationship. But so far as Islam is concerned, other relationship, it says it is haram. Divorce is easy, but divorce is pronounced means what would happen to that lady? What is the fault? She has got sick, she would suffer, and this boy, he likes that lady also very well. So a way has been given in Islamic law. In case of compelling circumstances, you are having a justifiable cause, and further condition is, if you are able to treat the second wife equally with first wife equally with the second wife, if you are able to treat both of them equally and comfortably, then you can take the second wife. So this is the condition imposed. Like this also, third, fourth, everything it is there. But so far as female are concerned, only monogamy is prescribed, or monogamy is recognized. But what about the children born to this marriage relationship, bigamous relationship? Whether it is for the first wife or second wife or third wife or fourth wife, the children are legitimate children. First wife having more right, second wife having lesser right, it is not that. All children are having similar rights which are recognized in Islamic law. Then so these are all the law governing the marital relationship of the Muslims. So there are other things consequent upon the divorce, this marriage, which is called divorce. Then division of properties, like that. It is a very big subject. So we can touch that subject in other occasions. Okay. Thank you.
Thank you, sir. Thank you, sir. Thank you very much, Sirajuddeen sir. We expected more law actually, honestly.
No, these are all laws only.
These are laws, I mean.
Only law.
But we expected intricacy, maintenance and other parts, intricacies, etc. But here it's a beginning, I can understand. So anyway, Nasir bhai, can you give the vote of thanks, please? We'll see next.
This is only Islamic law. Everything is available here.
So thank you very much for today, what you have said. We are very much appreciate about your special time and everybody. And whatever today you teach to us about the Muslim law, about the Muslim Sharia, Islamic, and then about the Shia law, Muslim Sunni law, and the mutual consent divorce, whatever the Muslim law, and the contract marriage. Today we have learned so much things, whatever you explained to us. Thank you to sir, whatever you been to us from all the sides. Thank you.
Can you give the book attendance, please? Where is that? Yeah, close that.